Okay, so there's a community note as well. This dissent is completely unreal. And then there's a chat community note. This never appeared in the dissent of any Supreme Court opinion and is a reference to an old meme called the breakfast question. The joke will be obvious to some readers, but others might not be aware of its background. I dissent with unyielding indignation from the majority's acquiescence to the petitioner's counsel's outrageous inquiry into my morning repast during oral argument. A question, how would your honor feel if you didn't have breakfast this morning, that is wholly devoid of legal relevance and constitutes an egregious affront to the dignity of this court. Such an impertinent question lacking any nexus to the multitudinous, I don't know what that word is, constitutional issues before us threatens to erode the independence of this tribunal by subjecting justices to trivial interrogacies better suited to a morning talk show than a court of law. In fact, I had already stated that I had eaten a full breakfast. I would hold that such questions do nothing to serve our democracy, and I admonish all litigants to refrain from such inquiries, God, I hate lawyer speak, on pain of sanctions, preserving the sanctity of this court's proceedings from the specter of any breakfast-related frivolity. To be fair, I can see how this would trick people even if they knew the breakfast question, because it would be entirely believable that someone asked this of Ketanji Brown Jackson. So I'm glad that there is the fucking note here saying that this wasn't real. That's the breakfast question in lawyerese. Imagine getting vibe checked that hard. Well, it's not real. Keep in mind, it wasn't real. That's why it's community noted. You don't know exactly what that chatter was referencing, but here's the case of the Trump executive order to end birthright citizenship, and the court getting as close in legalese as calling someone retarded as possible. What the fuck? Opinion of the court, page 23. We will not dwell on Justice Jackson's argument, which is at odds with more than 2 centuries worth of precedent, not to mention the Constitution itself. We observe only this. Justice Jackson decries an imperial executive while embracing an imperial judiciary. No one disputes that the executive has a duty to follow the law, but the judiciary does not have unbridled authority to enforce this obligation. In fact, sometimes the law prohibits the judiciary from doing so. See e.g. Marbury versus Madison, 1 Cranch 137, Cranch, concluding that James Madison had violated the law, but holding that the court lacked jurisdiction to issue a writ of mandamus ordering him to follow it. But see post at 15, Jackson dissenting, if courts do not have the authority to require the executive to adhere to law universally, compliance with law sometimes becomes a matter of executive prerogative. Observing the limits on judiciary authority, including, as relevant here, the boundaries of the Judiciary Act of 1789, is required by a judge's oath to follow the law. Justice Jackson skips over that part, because analyzing the governing statute involves boring legalese. Post at 3, she seeks to answer a far more basic question of enormous practical significance. May a federal court in the United States of America order the executive to follow the law? I bid, in other words, it is unnecessary to consider whether Congress has constrained the judiciary. What matters is how the judiciary may constrain the executive. Justice Jackson would do well to heed her own admonition. I can't read this when it's fucking split up like that. Because I wouldn't say admonishment, but then it ended in shun, admonition. Everyone from the president on down is bound by law. That goes for judges too. That's kind of fucking funny. That is actually fucking funny. Yeah, that's neat, but didn't ACB claim no standing in 2020? You ordered a steak, not a salad. Oh my god. She's so dumb, she was the judge that defended child rapists and gave them slaps on wrists. Oh my god, why? Why? Why would you do such a thing? Someone made Craig a female Loli Vtuber model. Please save him from the female avatar, IRL femboy, IRL trans pipeline while you're on SideScrollers. He actually kind of looks like my daughter.
What do you think, Blabs?
It's weird, man.
It is weird.
Makes a lot of sense. By the way, great use of AI right there. That's pretty quality.
All right.
Is this like would this be an AI background? You think? Should I do an AI background or like?
Yeah. Like I got your room in there. You got your button and the restroom sign.
Yeah, can we not turn Craig into a femboy, into like a weird trans VR chat gooner? Please give this man a male model. Please don't turn him into a woman, I beg. This is the one thing I crave, all right? We can't... I was the only VTuber on SideScrollers for ages. We can't introduce more VTubers and then turn Craig into a woman. All right, keep him a man, or I will revolt. I'm sick of it. Kirsche goes on SideScrollers. Craig becomes a femboy. She's got to be stopped. It's not even my fault. He's been a man.
Anyways, I'd like to thank Azahara right there for brainstorming my VTuber. We'll keep kicking it around, and we'll see.
I think it needs to look more like in their 20s and have boobs, and I think it'll be a lot better.
So the Supreme Court okays Tennessee's ban on gender-affirming care for kids. This article claims it is a setback for transgender rights. The Supreme Court on Wednesday upheld Tennessee's ban on gender-affirming care for transgender minors, a jolting setback to transgender rights. Thanks, Mark Sherman. The justice's 6-3 decision in a case from Tennessee effectively protects from legal challenges. The justice's 6-3 decision in a case from Tennessee effectively protects from legal challenges many efforts by President Donald Trump's Republican administration and state governments to roll back protections for transgender people. Another 26 states have laws similar to Tennessee's. Chief Justice John Roberts wrote for a conservative majority that the law banning puberty blockers and hormone treatments for trans minors doesn't violate the Constitution's Equal Protection Clause, which requires the government to treat similarly situated people the same. This case carries with it the weight of fierce scientific and policy debates about the safety, efficacy, and propriety of medical treatments in an evolving field. The voices in these debates raise sincere concerns. The implications for all are profound, Roberts wrote. The Equal Protection Clause does not resolve these disagreements, nor does it afford us license to decide them as we see best. In a dissent for the court's 3 liberal justices that she summarized aloud in the courtroom, Justice Sonia Sotomayor wrote, "By retreating from meaningful judicial review, exactly where it matters the most, the court abandons transgender children and their families to political whims. In sadness, I dissent." The law also limits parents' decision-making ability for their children's health care, she wrote. The state's move on trans youth care. This is restricted, restrictions not in effect, restrictions struck down by court, and protected. Several Republican-led states have taken steps to bar access to gender-affirming care for transgender minors, which for people under 18 typically involves puberty blockers or other hormone treatments. Some Democratic-led states are instituting protections. So here, the yellow states have restrictions not in effect, and then there's a bright yellow that's restrictions struck down by the court in Arkansas. There's a whole swath of states in red that have restricted access, and then there's a bunch of gray states that have nothing at all going on. Kind of want to... Governor in 2024 signed a ban on gender-affirming surgeries and physician referrals for out-of-state surgery on January 1st. It does not address other care. Okay, so New Hampshire's just for surgeries and not restricted on hormones. Interesting. Oh, that was Arizona? What? I wasn't reading... I was reading New Hampshire. I wasn't reading Arizona. Oh, I called Arizona Arkansas. No, it is Arkansas. What are you talking about? This is Arkansas. Fucking gaslighting me? This is your voting blocks for next election? These people experiment on their children just so they can feel popular. Amazing! I know. It's gotten pretty fucking wild. Yeah, I'm kind of surprised that, like, Maine has protections for this stuff. I'm not surprised that Vermont, Mass, New York, Connecticut, New Jersey, not even Maryland surprises me. DC isn't surprising. Washington, Oregon, California, none of those are surprising. Minnesota's basically a fallen state at this point. Minnesota's like this weird freak country in the middle of our country at this point. Illinois, I guess that's kind of surprising to me that Illinois protects gender-affirming care. Colorado's not surprising. New Mexico, kind of surprising. I don't really know too much about New Mexico. Maine isn't really that surprising. Maine is a weird state to me because Maine has, like, this weird mix of purple. Like, they're very fiscally conservative, but socially liberal. Underneath this graph of the states and their state of healthcare for transgender minors, quote unquote, The Republican president has also sought to block federal spending on gender-affirming medical care for those under the age of 19, instead promoting talk therapy only to treat young transgender people. And the Supreme Court has allowed him to kick transgender service members out of the military, even as court fights continue. The president signed another order to define the sexes as only male and female. I think that's interesting that instead of calling him President Donald Trump or President Trump, they said the Republican president. Like, they don't even want to name him. The debate even spilled into Congress when Delaware elected Democrat Sarah McBride as the first transgender member of the House. Her election prompted immediate opposition among Republicans, including House Speaker Mike Johnson of Louisiana and Rep. Nancy Mace of South Carolina, over which bathroom McBride could use. Some providers have stopped treatment already. Several states where gender-affirming care remains in place have adopted laws or state executive orders seeking to protect it. But since Trump's executive order, some providers have ceased some treatments. For instance, Penn Medicine in Philadelphia announced last month it wouldn't provide surgeries for patients under 19. I always find it weird when they say that, like, they announced that they're not going to provide surgeries for people under certain ages, because for ages they were just like, well, those aren't even happening. So, the president of the American Academy of Pediatrics, Dr. Susan Cressley, said the organization is unwavering in its support of gender-affirming care and stands with pediatricians and families making healthcare decisions together and free from political interference. 5 years ago, the Supreme Court ruled LGBTQ people are protected by a landmark federal civil rights law that prohibits sex discrimination in the workplace. That decision is unaffected by Wednesday's ruling. But the justices declined to apply the same sort of analysis the court used in 2020 when it found sex plays an unmistakable role in employers' decisions to punish transgender people for traits and behavior they otherwise tolerate. Roberts joined that opinion written by Justice Neil Gorsuch, who was a part of Wednesday's majority. Justice Amy Coney Barrett also fully joined the majority, but wrote separately to emphasize that laws classifying people based on transgender status should not receive any special reviews by courts. Barrett, also writing for Justice Clarence Thomas, wrote that courts must give legislatures flexibility to make policy in this area. Chase Strangio, the American Civil Liberties Union lawyer who argued the case for transgender minors and their families, called the ruling a devastating loss for transgender people, our families, and everyone who cares about the Constitution. Mo Jenkins, a 26-year-old trans woman who began taking hormone therapy at 16, said she was disheartened but not surprised by the ruling. Trans people are not going to disappear, said Jenkins, a Texas native and legislative staffer at the state capitol in Austin. Texas outlawed puberty blockers and hormone treatment for minors in 2023. Tennessee's leading Republican elected officials all praised the outcome. Acting Attorney General Jonathan Skrmetti, what a spelling, on social media called the ruling a landmark victory for Tennessee at SCOTUS in defense of America's children. There are about 300,000 people between the ages of 13 and 17 and 1.3 million adults who identify as transgender in the U.S., according to the Williams Institute, a think tank at the UCLA School of Law that researches sexual orientation and gender identity demographics. When the case was argued in December, then President Joe Biden's Democratic administration and families of transgender adolescents called on the High Court to strike down the Tennessee ban as unlawful sex discrimination and to protect the constitutional rights of vulnerable Americans. They argued the law violates the Equal Protection Clause of the 14th Amendment in part because the same treatments that the law prohibits for transgender minors can be used for other purposes. I feel like that's very disingenuous, right? Because, like, just because there are some children who are born with certain conditions that mean they need hormone therapy as a part of a natural biological process because they were born with a condition that otherwise stunts that natural growth, I don't think that someone with a mental condition such as dysphoria should apply physical body blocking procedures to children in the same position. Surgery and puberty blockers are not the solution to mental illness. Yeah, personally, I'm not a doctor, so like my opinion is probably not crazy important here, but I don't think you should be treating a mental health condition with physical body changes. And it's like, I guess there can be, as an adult, some leeway for that, because as an adult you can make any kind of body modifications to yourself and nobody's gonna really care. But once it starts becoming a policy, once it starts becoming something taxpayer dollars pay for, once it starts becoming something that affects children, then it starts being a much larger conversation. Soon after Trump took office, the Justice Department told the court its position had changed. A major issue in the case was the appropriate level of scrutiny courts should apply to such laws. The lowest level is known as rational basis review, and almost every law looked at that way is upheld. Indeed, the federal appeals court in Cincinnati that allowed the Tennessee law to be enforced held that lawmakers acted rationally to regulate medical procedures. The appeals court revised a trial court that employed a higher level of review, heightened scrutiny, which applies in cases of sex discrimination. Under this more searching examination, the state must identify an important objective and show the law helps accomplish it. Roberts' 24-page majority opinion was devoted almost entirely to explaining why the Tennessee law, called SB 1, should be evaluated under the lower standard of review. The law's restrictions on treating minors for gender dysphoria turn on age and medical use, not sex, Roberts wrote. Doctors may prescribe puberty blockers and hormone therapy to minors of any sex to treat some disorders, but not those relating to transgender status, he wrote. In her courtroom statement, Sotomayor asserted that similar arguments were made to defend the Virginia law prohibiting interracial marriage that the Supreme Court struck down in 1967. All right, I don't know. I was not around in 1967, but I'm going to go out on a limb and say that it is absolutely asinine to try and equate interracial marriage to transgenderism in any way, shape, or form. Like, that's crazy. A ban on interracial marriage could be described in the same way as the majority described in SB 1, she said. Roberts rejected the Yeah, I feel like any sane person would reject that comparison, man. So we just read about the Supreme Court okaying the Tennessee ban on gender-affirming care. I was like, that's great. This is a win. We're protecting the children. But then there's this that came out a few days later. This was yesterday. The Supreme Court throws out appellate rulings in favor of transgender people in 4 states. The Supreme Court on Monday threw out appellate rulings in favor of transgender people in 4 states following the justice's recent decision upholding a Tennessee ban on certain medical treatment for transgender youth. The justices took no action in cases from Arizona, Idaho, and West Virginia involving the participation of transgender students on school sports teams. The court could say as soon as Thursday whether it will take up this issue in its next term. The High Court ordered appellate judges to re-examine cases from Idaho, North Carolina, Oklahoma, and West Virginia involving access to medical care and birth certificates. The action was unsurprising because the court had set the cases aside until after it decided the Tennessee case, as typically happens when the same legal issue is being considered. The rulings all included findings that the restrictions on transgender people imposed by the states violate the Constitution's Equal Protection Clause. In the Tennessee case, the Supreme Court ruled that there was no constitutional violation in a state law prohibiting puberty blockers and hormone therapy to treat gender dysphoria in people younger than 18. The justices ordered the 4th U.S. Circuit Court of Appeals in Richmond, Virginia, to review its decision that West Virginia and North Carolina's refusal to cover certain health care for transgender people with government-sponsored insurance is discriminatory. The San Francisco-based 9th U.S. Circuit Court of Appeals will get back a case from Idaho stemming from the state's ban on certain surgical procedures for Medicaid recipients. The 10th U.S. Circuit Court of Appeals in Denver will review its ruling blocking an Oklahoma ban on people changing their gender on birth certificates. In one other case from Kentucky, the justices rejected the appeal of transgender minors and their families, challenging that state's ban on gender-affirming care. So, what I don't understand here is maybe it's the way that it's worded, right? So if the Supreme Court said that the Tennessee ban is fine, why are they throwing out rulings to favor transgender people in 4 other states, is my question. Because shouldn't these all be the exact same as the Tennessee one? If they ruled the Tennessee one was fine? I am minorly confused. And like, maybe I'm reading it wrong, but like the title, I guess, is written in a confusing way. The title is bad. The rulings were in favor of trans. The rulings got thrown out. Oh, okay, I see. So the appellate rulings are the ones that are in favor of transgender people, and the Supreme Court threw them all out. Okay, that makes a bit more sense. But The High Court ordered the appellate judges to re-examine the cases from Idaho, North Carolina, Oklahoma, and West Virginia involving access to medical care and birth certificates. The rulings all included findings that the restrictions on transgender people imposed by the states violate the Constitution. So, it's saying the rulings that the Supreme Court is asking them to re-look at, the rulings that were thrown out said that the restrictions violate the Constitution, and the Supreme Court said, no, go back and look at them again. The wording is a little screwy, you agree? Okay, the article's bad. The Supreme Court is sending the cases back to the courts to review them based on the Supreme Court's decision on the Tennessee case. And this is the third article that I brought up about this specifically, because, and let me see if it's still in my history, but the article that I originally had was from ABC News, and it's the same title. And then they say down here, Washington, and then they put AP in brackets, and then it's literally a copy paste of the entire article. So, like, nobody even wrote this on ABC. Yeah, by Mark Sherman, the Associated. They just republished it at ABC. Okay, all right. The AP's entire jam is to publish articles, and then the other news places run the article. Oh, okay, I see. They sub it out. Okay. Because, yeah, when I first read this, I was like, am I fucking retarded? Because it sounds like, from reading this, it sounds like the Supreme Court, like, was in favor of transgender people for these other 4 rulings. And then I was like, that doesn't make any sense with what just happened with Tennessee, though. UPenn has agreed to apologize for allowing Male Lia Thomas to compete on the women's swimming team. They will also vacate all of Thomas's records and restore them to the women who rightfully earned them. This is a crazy fucking win, holy shit. I don't know if we ever made it into a short clip, we probably didn't, but probably like a year or 2 ago at this point, I went through Mr. Thomas's background here, and Mr. Thomas, wow, to no one's sane surprise, was just an autogynephiliac and not a transgender person whatsoever. Their social media accounts were just completely littered with fetishistic material, and they were dating someone who was also a fetishist. Wow, who could have seen that coming? Who could have predicted this? The Department of Education announced that the University of Pennsylvania has agreed to resolve Title IX violations related to allowing transgender swimmer Lia Thomas to compete on the women's team during the 2021-22 season. As part of the resolution deal, UPenn will adopt definitions for male and female consistent with biological sex, restore stolen records and titles to female athletes, and issue personal apologies to each impacted female swimmer. That is crazy. That is so fucking nice to read. Holy shit. How long do you think it'll take before all of the stolen records and titles, all of the awardmanships, all of the scholarships, everything is finally restored to the rightful winners and taken away from these fetishistic or just loser men who wanted to take advantage of a system that knew would capitulate to them claiming an identity that they don't actually have? One of those swimmers is Paula Scanlon, a teammate of Thomas, who had previously expressed the emotional distress she suffered from being forced to change with a biological male in the women's locker room for an entire season. I am deeply grateful to the Trump administration for standing firm in protecting women and girls and restoring our rightful accolades, Scanlon told Outkick. It is because of their strong leadership that my alma mater now knows it has no choice but to begin the process of reforming its policies to uphold women's rights. Today marks a momentous step towards repairing the past mistreatment of female athletes and forging a future where sex discrimination no longer limits girls' potential. In April, the Department of Education Office for Civil Rights ruled that the University of Pennsylvania violated Title IX by allowing Thomas to compete on the women's team. Acting Assistant Secretary for Civil Rights Craig Traynor said at the time that UPenn could face financial consequences if they don't comply. While UPenn is a private school, it received about $1 billion in federal funds in 2024, according to Why. Unlike the state of Maine, which continues to fight the federal government despite also being found in violation of Title IX, UPenn made the appropriate decision to stop allowing males to compete in women's athletics. Maine, what the fuck is you doing? Why you like this? Today's resolution agreement with UPenn is yet another example of the Trump effect in action. Thanks to the leadership of President Trump, UPenn has agreed both to apologize for its past Title IX violations and to ensure that women's sports are protected at the university for future generations of female athletes. U.S. Secretary of Education Linda McMahon said in a statement, "I pronounced it right. Today is a great victory for women and girls, not only at the University of Pennsylvania, but across our nation. The department commends UPenn for rectifying its past harms against women and girls, and we will continue to fight relentlessly to restore Title IX's proper application and enforce it to the fullest extent of the law. McMahon also spoke to Outkick about the resolution and emphasized the importance of UPenn both apologizing to its female athletes and erasing Thomas's records from the books and restoring them to the women who earned them. We wanted to make sure that it was emphasized that this was wrong and the university didn't take the right kind of action, and to apologize to these women for putting them in situations where they could have been hurt or where they would have lost opportunity or where they might have had their dignity impugned because impugned? I feel like that should be impugned because they had no change in private spaces in front of males. So I think an apology was absolutely warranted, Mick Mahone said. One of the big things that is happening with this resolution is the University of Pennsylvania is going to restore all the Division I women's records and titles or similar recognitions to the women who actually did win them, save for competing against a man. And I think that's a really big thing. It is. It's huge. It's huge, and I hope this is the beginning of the domino stack tipping, and that every single man that competed in women's sports against women get all of their records just completely nullified. I live to see this happening. While Mick Mahone wasn't able to comment on the ongoing investigations into Title IX violations by Maine, California, and Minnesota, she did note that she hopes the UPenn resolution will encourage those states to comply with federal law. That's certainly our hope, and as we continue our investigations, we'll be using this resolution as a model to go by. Outkick reached out to the University of Pennsylvania for comment on the resolution, but have not yet heard back. Riley Gaines, host of the Outkick podcast, Gaines for Girls, I didn't know that, and one of the most influential pro-women voices in the country, told Outkick that Tuesday's resolution is further proof that President Trump and his government agencies are committed to a pro-woman agenda. From day one, President Trump and Secretary McMahon made it clear that protecting women and girls is a top priority, and today's agreement with UPenn is proof of that commitment in action. Gaines, who tied Thomas for 5th place in the 200-yard freestyle at the 2022 NCAA Swimming and Diving Championships, added that the UPenn resolution should send a clear message to colleges and universities across the country. This administration isn't just talking about women's equality, but instead actively defending it. I hope this sends a clear message to educational institutions that you can no longer disregard women's civil rights. And to every female athlete, know this: your dignity, safety, and fairness matter, and our nation's leaders will not stop fighting for them. That's hella fucking good, man. Hella good. Munya.